All right, well, let's get started if we could. Good morning and welcome. My name is Dean Reuter. I'm the Director of Practice Groups and a Vice President here at the Federalist Society. Thank you all for being here this morning, especially at this early hour. I mentioned yesterday morning, and I'll repeat it very briefly today, as Director of the Practice Groups, we do an awful lot at the Federalist Society. Most of what we do, we accomplish through the use of our volunteers, and we have what I would describe as a tight group of core volunteers. I would like to loosen that group and expand it to include people who are in the audience today. So several of you have taken me up on my invitation yesterday to approach me, but if you are interested, please see me after class. We'd love to have more volunteers. We have an unusually tight schedule today, especially this afternoon, but I blame that on the audience. We keep getting feedback from folks like you that we want more and more programming, so we've tried to accommodate you by squeezing more and more into the schedule. So that accounts for the tight schedule this afternoon. I hope everybody's had a good time at the convention. This is the best day of the convention today, so thank you for being here. We heard from Judge Gorsuch last night. I thought he was extraordinary, and of course, Governor Walker was really something, and as he talked about public sector jobs and governance and so forth, I was reminded of a very quick joke that I will tell, and it concerns a public sector employee who's talking to his private sector friend, and he's bemoaning the fact that his pension is changing and his retirement benefits are changing, his health care is changing, and it's just all terrible the way he's being treated in his job. And his private sector friend looks at him and says, well, what's a job? So, could be worse, and it is worse for some people. So, but let's get right to the program today. Our third showcase panel, this one is discussing deference in administrative law, and I'm very pleased to welcome back a repeat offender to our moderator slot, our Fifth Circuit Court of Appeals Judge, Jennifer Elrod. Thank you for doing this.
Thank you, Dean. I think you've been calling all of the Fifth Circuit judges who are here repeat offenders. I hope we're not in big trouble. And he does say that every day is the best day. I heard him say that yesterday, but I'm so glad that today is truly the best day. It is a privilege to be with you here this morning. As someone who has been a member of the Federalist Society since law school, it is always gratifying to come to DC and see so many students, the next generation of lawyers, here eager to learn from the leading scholars in the fields about the Constitution and the separation of powers and limited government. Speaking of leading scholars, we have a very distinguished panel here today. First is Professor Kristen Hickman. Professor Kristen Hickman is the Harlan Albert Rogers Professor of Law at the University of Minnesota Law School. She also taught at Harvard Law School and Northwestern University School of Law. In fact, I believe all of our panelists here today have a Northwestern connection. Professor Hickman teaches and writes primarily in the areas of tax law, administrative law, and statutory interpretation, and her articles have appeared in numerous journals. Her work on Chevron's domain with Professor Merrill was cited by the United States Supreme Court in United States versus Meade, and several of Professor Hickman's articles have been cited in judicial opinions and other briefs. She also co-authors the Administrative Law Treatise and a case book on federal administrative law. She received her BS degree in business administration with a concentration in accounting and a secondary major in history from Trinity University in San Antonio, Texas. And after practicing several years as a CPA, Professor Hickman then earned her JD degree magna cum laude from Northwestern, where she was awarded the Raoul Berger Prize for her work on Chevron's domain. Following law school, Professor Hickman clerked for the Honorable David B. Sintel of the United States Court of Appeals for the District of Columbia. We're glad to have Professor Hickman with us here today. Our next panelist, Professor Jide Nzelebe, is a professor of law and associate dean for faculty and research at Northwestern University Law School. He has been teaching at Northwestern since 2004, and his research interests are in international trade, foreign relations, international law, the administrative state, international humanitarian law, and the separation of powers. He has been a visiting professor at the law schools of the University of Chicago, Tel Aviv University, Harvard University, and New York University. He received his law degree from Yale Law School and clerked for the Honorable Stephen F. Williams of the United States Court of Appeals of the D.C. Circuit. He worked at a law firm here in Washington, D.C. for a few years before joining the Legal Academy. Welcome, Professor Inzalebe. Professor Tom Merrill is the Charles Evan Hughes Professor of Law at Columbia Law School, where he writes widely in the fields of property and administrative law. He has written a number of works about the history of administrative law and about judicial review of agency interpretations of law. Professor Merrill is a graduate of Grinnell College and Oxford University, where he was a Rhodes Scholar. He is also a graduate of the University of Chicago Law School. He clerked for the D.C. Circuit and then for Justice Harry A. Blackmun of the U.S. Supreme Court. From 1987 to 1990, he was Deputy Solicitor General in the U.S. Department of Justice. Professor Merrill has previously taught at Northwestern Law School and at Yale Law School, and he is a member of the American Academy of Arts and Sciences. Our last panelist today is Professor Philip Andrew Hamburger. He is the Maurice and Hilda Friedman Professor of Law at Columbia, and his scholarship focuses on constitutional law and its history. His publications include Separation of Church and State, Religious Liberty in Philadelphia, The New Censorship, More is Less, Law and Judicial Duty, Liberality, and one that sounds quite intriguing, Revolution and Judicial Review. Before coming to Columbia, Professor Hamburger was the John P. Wilson Professor at the University of Chicago Law School, where he was the director of the Bigelow Program and the Legal History Program. He has been a visiting professor at the University of Virginia Law School, at Northwestern Law School, and he was in private practice in Philadelphia before he took an academic turn. We welcome our very distinguished panelists. You should be familiar with our format by now. The format for today is as follows. Each panelist will speak for a few minutes, and then the panelists will have an opportunity to respond to each other's remarks, and then we will conclude with questions from the audience. The topic for discussion, do you think we're going to conclude? See, we're already having a lively interchange between the panelists. The topic for discussion is formalism and deference in administrative law. As we know, the landmark case of Chevron v. Natural Resources Defense Council has changed the face of modern administrative law. The panel will address the rightness and limitations of Chevron deference, especially in the context of the agency decisions on the scope of the agency's jurisdictional mandate. Should the federal courts defer, or should they not defer in these contexts? We need guidance. Justices Scalia and Thomas recently differed from Chief Justice Roberts and Justices Kennedy and Alito on these issues. Who is right and why? Does the answer depend in any measure on the growth of the administrative state? And are there larger issues of jurisprudential philosophy at stake? It may just come down to, what are you really afraid of in this fundamental disagreement that the justices are having? Chief Justice Roberts describes it as a fundamental disagreement. Are you afraid, as Justice Scalia discusses, of a lack of stability and chaos, of unaccountable federal judges running muckety-muck, deciding numerous issues in various sundry ways? Or, as the Chief Justice recounts, are you afraid, in the words of Madison, of the accumulation of all powers, legislative, executive, and judiciary, in the same hands in a vast and ever-growing administrative state? We look forward to a lively discussion on this topic. Thank you. Professor Hickman.
Good morning. Is this working? Okay, good. So I'm going to talk mostly about the Meade case, actually. This panel's about Chevron. But rather than talking about Chevron, I'm going to talk about Meade because to me, that is where the action is. Judges may apply Chevron differently, particularly at Chevron step 1, where some judges would find ambiguity in a stop sign, and other judges will pull every tool out of the statutory interpretation toolbox, but not a single one of the justices of the Supreme Court is willing to come out and say, hey, let's rethink this whole Chevron thing. I think there are good reasons for that. There are just some questions that can't be effectively answered using traditional tools of statutory construction, and in those instances, agencies are simply in a better position to fill the gaps. They're better equipped than the courts because of their expertise and otherwise. But once you accept that Chevron is here to stay, then it seems to me that the focus really has to shift over to Meade. Now, since I'm first on this panel, I'm going to start with just a little bit of background to make sure that everyone here knows what we're talking about. Then I'm going to offer a vision, or really 3 competing visions of Meade and Chevron that I draw from the text and jurisprudence of the Supreme Court. And finally, to the extent that I have time, then I'm going to talk about why these competing visions explain the outcome in the recent City of Arlington case, and also make future closed cases hard to predict, including one facing the Supreme Court this term, the Quality Stores case, in which the court may have to decide the standard of review for IRS revenue rulings. So for several years now, the court has recognized 2 competing standards of review for evaluating the substantive validity of agency interpretations of statutes. One is the 2-step test of Chevron. First, the court assesses the clarity of the relevant statute, and if the statute's meaning is clear, then that's the end of the inquiry, because both agencies and courts must defer to and respect the clearly expressed intent of Congress. But if the statute is ambiguous, then the Chevron second step calls upon a reviewing court to defer to any permissible interpretation of the statute. Skidmore is the second available standard that the court uses to evaluate agency interpretations of statutes. Skidmore and related cases call upon reviewing courts to consider various factors in determining the degree of deference that is appropriate for given agency legal interpretations, including but not limited to the thoroughness evident in its consideration, the validity of its reasoning, and its consistency with earlier and later pronouncements. In Meade, the court adopted another 2-part test for evaluating whether Chevron or Skidmore provides the appropriate evaluative standard for a particular agency interpretation of a statute. The Meade test asks whether Congress has given the agency in question the authority to bind regulated parties with the force of law, and whether the agency action in question is an exercise of that congressionally delegated power to act with the force of law. Where the answers to both of Meade's questions are affirmative, then Chevron provides the standard of review. If the answer to either of Meade's questions is negative, then Skidmore offers the appropriate evaluative standard. Now, as with Chevron, the rhetoric the justices use in talking about Meade is not always consistent. In large part, I think that is because, as I read the jurisprudence, notwithstanding that Meade was an 8-to-1 decision with only Justice Scalia dissenting, we really see 3 rather than 2 distinct visions of the relationship among Meade, Chevron, and Skidmore in the court's jurisprudence. Those 3 versions are best exemplified, I think, by the 3 opinions by Justice Thomas, Justice Scalia, and Justice Breyer in a case called Christensen versus Harris County, which predates Meade by about a year and foreshadows Meade. And you see the themes of those opinions, the justices' opinions in Christensen, throughout the court's post-Meade jurisprudence. So to me, Christensen is really the Rosetta Stone for figuring out that post-Meade jurisprudence. Justice Thomas's opinions, particularly in Christensen, but later in Brand X as well, reflect what I call the decision tree model. Meade has 2 steps. Yes or no questions. They in turn lead to either Chevron or Skidmore, which are 2 distinct standards of review. And if you go to Chevron, then you have its 2 steps and you take them in turn. Whereas if you go to Skidmore, then you take Skidmore's contextual factors, which can also be applied somewhat formalistically by looking at the individual factors. And while you don't precisely add them up, we've got 3 factors on one side and 2 on the other. Nevertheless, you look to see whether they're present or absent. We can quibble over whether Mead is a step 0 or a step 1.5, as some scholars have talked about. But either way, each step on the decision tree asks its own discrete question, and you have to hit each step of the inquiry one at a time. And this model, as it sounds, is a fairly formalistic approach to Mead and Chevron and Skidmore and the question of deference. Justice Breyer's opinions, particularly in Christensen, and then later on in Barnhart versus Walton and a few other cases, reflect what I call the impressionist painting model of Mead, Chevron, and Skidmore. Justice Breyer views all three of those cases as one big happy standard with a whole bunch of factors that we look at together. Like Justice Thomas, he's happy to emphasize delegation as very, very important. That's what Mead talks about and a lot of its progeny talk about. But in the end, Justice Breyer just throws delegation, traditional tools of statutory construction, and Skidmore's contextual factors all at the canvas together to see what picture emerges. The delegation factor that's so central to Mead operates as kind of a super factor, really like kind of a bright color that pops out of the canvas a little more than some of the other hues. But at the end of the day, I don't really think that Justice Breyer considers delegation absolutely essential for Chevron deference. It's just another factor. Justice Scalia more or less stands alone when it comes to Mead, Chevron, and Skidmore. He hates Mead. He thinks Skidmore is completely anachronistic, and deference for him is a matter of Chevron or no deference at all. He really focuses on those tools of statutory construction. Any authoritative agency interpretation that gets past those and reflects agency expertise is eligible for Chevron deference. In his own way, Justice Scalia's approach is just as impressionistic, I think, as Justice Breyer's. He just uses fewer factors, emphasizing expertise and leaving out delegation and Skidmore's contextual factors. So it seems to me, then, taking those different views, if you go look at what the circuit courts are doing, they overwhelmingly seem to apply the decision tree model of Mead, Chevron, and Skidmore. And I think this is a really great model because in most cases, it yields very clear answers about whether Chevron or Skidmore provides the right standard of review, largely based on the format that the agency uses to articulate its interpretation of the law. So notice and comment rulemaking and formal adjudication get Chevron, informal guidance and most informal adjudications get Skidmore. There are a few close cases, but most of the cases can fall into one of those two groups. At the Supreme Court, Justice Scalia notwithstanding, Justice Thomas's decision tree and Justice Breyer's impressionist painting use the same language, usually yield the same results in terms of whether Chevron or Skidmore provides the right evaluative standard. But when you get to some of the closer cases, like City of Arlington, that agreement starts to fall apart. So City of Arlington asked whether Chevron deference is appropriate when the interpretive question at issue goes to the heart of an agency's jurisdiction. Using the decision tree model, the argument really came down to whether Mead's first step asks courts to consider delegation statute by statute or provision by provision. And the court in the past has talked about Mead as a statute by statute kind of an inquiry. For Chevron not to apply in the context of jurisdictional questions, Mead's first step would have to go to a provision by provision inquiry, looking at individual provisions of the statute in delegation terms. The problem with taking Mead to the individual provision level is it leaves you with very little or nothing left to do as you go down the decision tree and get to Chevron step 1. In other words, the sheer awkwardness of fitting that jurisdictional question exception from Chevron into the decision tree model dooms that argument. With a more impressionist approach to Mead and Chevron, remember we're looking at delegation, traditional tools of statutory construction, and contextual factors altogether. Or in Justice Scalia's view, fewer factors than that, but we're still looking at everything kind of together at a Chevron step 1 level. Once you approach things with that impressionist model, there's really no room to pull out an independent jurisdictional check. It just gets thrown into the mush. And anything that takes you outside that impressionistic bubble is going to get rejected. I think at this point in time at the Supreme Court, we have more impressionists than we have decision tree people. And that's really how it ends up breaking down and why City of Arlington came out the way that it did. Quality stores, I'm about out of time. Quality stores that's coming up this semester yields a similar but slightly different problem. IRS revenue rulings are informal guidance documents in the sense that they don't go through notice and comment rulemaking, but they're legally formal in the sense that you can be penalized for failing to comply with them. So when you start with the decision tree model, you're looking at Meade and saying, well, you know, Congress has clearly delegated the power to the agency to act with the force of law. They decided that in a case called Mayo a couple years ago when you're talking about Treasury and the IRS. And clearly, because of the penalties, it seems like revenue rulings carry the force of law, no matter how you want to slice and dice that term, which takes you to Chevron. But these things don't have notice and comment, which is really troubling if you're going to apply Chevron the way that it applies. I filed an amicus brief yesterday in which I sort of say, well, maybe we can get to Chevron step 2 and just declare them all unreasonable. But the decision tree model doesn't work very well with revenue rulings. The impressionistic model, on the other hand, we're just throwing everything in together. And maybe, I don't know whether we'll come out Chevron or Skidmore on that one. Probably Skidmore. We'll have to wait and see. But it's because it's equally awkward. I'm really curious to see how it comes out. I don't know what's going to happen, but keep an eye out for that one, and we'll see if my impressionist painting versus decision tree model ends up holding steady with that case as well. Thank you very much.
Good morning. I have a little confession to make. I'm a sort of a, I think Professor Hamburger may join me in this confession. I'm sort of a stranger in the mix here. I am not really, in many ways, an administrative law person. I encounter administrative law occasionally when I teach international trade, and we get to anti-dumping stuff in the course, and it has to do with calculating anti-dumping margins and how the Department of Commerce and Court of International Trade deal with it. And usually what I do in that context is that I bribe the class with Girl Scout cookies to make it through. Until we get to the fun WTO stuff that they're waiting for. In any event, there's something about this that I think may be helpful, which is when I come in and read City of Arlington, and I say to myself, I read through it, I say, who am I rooting for here? And one of the big questions, and one way to look at what I'm going to present here is sort of a realist perspective of City of Arlington. Who are you rooting for if you like limited government? Should you, or if you desire limited government, should you be rooting for Scalia or should you be rooting for Roberts? Now, look at what Scalia is concerned about in City of Arlington. The typical motive of Scalia, right? Clarity. There has to be a clear line here. You're opening up multiple ways in which courts can go in different directions, right? Let's have one deference rule here. Let's call it Chevron, and let's work with it, right? All this new stuff that you're putting in, there has to be a different standard when you come to jurisdiction and something else, is just going to blur the lines. Lawyers are very, very clever. They'll throw in and claim something is jurisdiction when it isn't, and we won't be able to sort it out. Now, then you look at Justice Roberts, and Justice Roberts is, I don't know if people have seen the dissent. The beginning of the dissent reads like an anti-Leviathan screed. The administrative state is growing, it's getting out of control, they're doing everything. And here's one suggestion. If you want to fight the Leviathan, I don't think having courts not defer on whether something is an interpretative authority or jurisdiction will get you much traction. Many of the cases where this has come up have not to do with efforts to limit an agency in a pure sense, right? And the devices in which the agency expands probably have very little to do with whether or not you're using Chevron deference or some other form of deference. And one of the reasons why I think this is important is that think about Scalia's longevity on the court, right? He is one of these people who has seen it all. And he was one of the people who was actually serving on a court when Chevron came by. He was on the D.C. Circuit. And by the way, he wrote an article for it, right? He wrote an article about it. So did, by the way, his fellow then D.C. Circuit judge, a gentleman by the name of Kenneth Starr. They both write. Ken Starr wrote an article. He wrote an article. And they were very happy that Chevron arrived on the scene because they knew what the world was like pre-Chevron, and it wasn't a very pretty world. And one of the reasons why Chevron was nice to them is one of the reasons that I don't think we appreciate it so much is that they were in a deregulatory phase, right? This was at a time when there was an effort, right, for agencies to cut back, and there was political pressure because people were pressuring, right? Because there are constituencies. Because Reagan won on an electoral platform that says, I will break the growth of government, right? And one of the things he did was try to get some of these agencies to push back. But courts were looking at this and saying, by their natural role as judges, they're saying something is wrong here. There was a statute passed some time ago. You, the agency, said that it meant the following thing. Here come by a couple of years later, you're pulling away. Something is wrong. We ought not to let you do that. And from the perspective of Chevron, it was considered a very nice device because agencies could change course, even if it's under political pressure, and they decide to deregulate, and courts won't come up and say, I insist, right, in the name of the law, that you regulate, right? The agency can say, well, you know, I'm under pressure. There's 16 different interest groups and powerful politicians that are on my head who don't want me to regulate. I may have to back off. And maybe the agency will give a sort of very, very nice sounding reason why it wasn't doing it. And maybe somebody like Breyer will say, I can smell through that. I know it's because the Republicans came into town that you're trying to pull back. And what Scalia was going to say to him is, so be it. That's how the political system works. You like something, a new administration comes in, they don't like it so much, they can pull back. And by the way, that is how often you fight the Leviathan. You don't fight the Leviathan by asking courts, who, according to my own definition and according to what last I saw, excuse me, Judge Elrod, are actually part of the state. You don't say to the state, hey, you're growing, you're getting more power, please stop yourself, right? Go in and ask another anchor of your state to collaborate and stop yourself. No, what happens is that usually some interest group, some faction, some constituency says, I don't like the state growing into my affairs. I want it to back off. Then they campaign. Then they win. Then they tell the agency, back off, right? And that's how you can sometimes trim down on the Leviathan. The idea that courts will serve this role, I think, is a little bit problematic because whenever you have a vision of what you want a court to do, and you believe it will lead to certain consequences, and it's predicated on a certain notion, and I say, what is that notion? You say, well, I would like the court to do this, and I would say, depending on what? What is it contingent on? Contingent upon them having these people serving, people like Judge Errol, people like Judge this, people like Judge that, and I'm like, what if they don't have those people? What if you don't get the libertarian on the bench? What if it's a different set of judges? If you like courts, the way I would say it as an institutional actor, imagine the judge that you dislike the most and say, imagine 9 of them are serving on the Supreme Court. Would I feel comfortable having them having jurisdiction over this kind of activity? And if you say yes, then I would say go ahead. But if it's contingent, then I would say it's probably not a good idea because that is a very peripheral and myopic view. One day, the course will shift. And when it shifts, you'll be left alone. By the way, beyond that, there's another problem with all of this, which is even if you strip away what courts do, and I do think there's something about what courts do, there's a certain kind of integrity, right? Most of us may feel that if we want something like consistency or impartiality, going through a judge, right, and saying, look, here's this license, it's been awarded to some company because, right, there was a Republican legislator in their district. Most people agree that whether or not the judge is left-leaning or right-leaning, they may strike that down. That kind of arbitrariness, that is sheer politics, courts don't like. But the problem is that that consistency that you value in courts can come and bite you if you're interested in having what I would call policy variation in what agencies do. Because what happens, and you see this in Breyer, is that again and again the court will say, why did you, the agency, tell me this 17 years ago, and now you're telling me something different? Why? I want you to be consistent. But if you want to trim back the Leviathan, sometimes I think it behooves you that the agency is not consistent, that it could say, I don't want to follow this path anymore, right? And that, I think, is something that Scalia might have seen. That, I think, is a lesson. He knows a way, or he knows back at a time when Chevron wasn't in the picture, and he saw what courts are doing, and he saw how they could act, and he knew that courts can sometimes go into an agency and say, I want you to do more, right? You haven't, and somebody can challenge and bring an agency claim and says that agency hasn't done enough, and the court can say, I want you to do more. He's seen all of that. He's been around the block, and therefore, I would say if you're rooting for limiting the Leviathan, I do think that Scalia has a better take on this than Roberts, and I'll leave it at that.
Well, two very thoughtful takes on Arlington. First, a disclaimer or a confession of sorts. I did an amicus brief in Arlington on behalf of the state and local governments. It reads a lot like Chief Justice Roberts' dissent, although not as eloquently put as his dissent, so at least you know where I'm coming from here. I think it's appropriate to step back a little bit from the intricacies of the jurisprudence of the Chevron doctrine, although I'll get back to that eventually. And ask, why do we have judicial review of agency action in the first place? Maybe we shouldn't. Maybe the Supreme Court and the federal courts should just confine themselves to issues of individual constitutional rights and statutory interpretation and diversity cases and so forth. But why do we have a judicial review of agency action? Well, one argument classically is that it helps ensure fairness to individuals, that individuals get caught up in the administrative state. Frequently, agencies misunderstand their circumstances, and courts can act as a corrective in terms of making sure that individuals are not treated on the basis of improper understandings of the facts that pertain to their particular case. And I think this is still an important function of judicial review. If you look at what happens in the federal district courts, for example, I think you would see this going forward. At the jurisprudential level, however, both Congress and the Supreme Court have largely ceded authority to agencies to engage in fact-finding in individual cases. Courts provide very deferential review of agency fact-finding, and so judicial review is there as a backstop, but it applies rather weakly, and deference, the theme of our panel, has sort of taken over in terms of protecting individuals against unfair treatment. Another rationale might be to sort of monitor the policymaking of agencies to make sure that agencies are acting in a reasonable or rational fashion when they articulate policy. The hard look doctrine that became very fashionable in the 1970s seems to point toward this being a rationale for judicial review. And again, we still have that on the books. There is still occasions when courts will question the reasoned decision-making or the lack thereof of agencies, and will send cases back for further elaboration. But the trend here also seems toward increasing deference. A few terms ago, in a case called FCC versus Fox Broadcasting, the court seemed to cut back sharply on the degree of reasoning that is needed in order to justify an agency change in policy. So again, deference seems to be washing over that particular function of judicial review of agency policymaking. The last great rationale is what my colleague Henry Monahan calls boundary maintenance. And here the purpose of judicial review is to make sure that the allocation of powers in our society between government agencies, different branches of government, different levels of government, and between government and individuals is maintained. It's partly a function of protecting the individual against Leviathan, but it goes much beyond that. It's also making sure that the checks and balances that operate within our government are maintained, and that one branch of government does not usurp the authority properly given to another branch of government. if I ask myself the question of how are we going to maintain the sort of boundaries between different agencies, between agencies and courts, between the federal government and the states, between the government and individuals, which branch of government has the best case for having a competency to do that? I don't think any branch has a clear, outstanding competence to do this, but I think that the judiciary, particularly the federal judiciary, has the best claim to be able to engage in this boundary maintenance function because they have more understanding of constitutional as well as statutory law. They have some sense of history. They have some sense of our evolved traditions. They have some sense of the competencies, the strengths and weaknesses of different levels and branches of government. They're experienced, and they have shown to be impartial and to exercise judgment. Agencies, I don't think, are nearly as well suited to engage in boundary maintenance. Agencies usually have fairly narrow missions. The people that work at agencies usually identify very strongly with those missions. They are not overly fond of sharing their power with other agencies or entities of government. And they would tend to be rather narrow gauge and not terribly conversant with broader constitutional traditions or historical understandings. And so I think if one were designing a system from scratch, boundary maintenance would be given to the courts and would not be given to the agencies. Arlington says the opposite. Arlington says that in a boundary maintenance case, and Arlington was a boundary maintenance case, it involved conflicts between both the courts and the FCC as to who was going to decide how rapidly wireless towers were going to be built out, what was a reasonable period of time for deciding local land use decisions, and a conflict between the states and the federal government because the decisions about local land use are classically handled by state land use planning boards and are reviewed by state courts, not by federal courts. So it was a boundary maintenance case, and the court 5-4 said that unless Congress speaks with clarity in a statute prescribing a boundary, the agency can decide through statutory interpretation what the boundary means, and the courts under Chevron will defer to the agency's decision. How did this possibly happen? How did the court seemingly cast its last unique rationale for engaging in judicial review of agency action into the deference pile along with fairness to individuals and agency policymaking? I think the explanation is provided if you listen or read the transcript of the oral argument. The Solicitor General Verrilli, who's had some rough days at oral argument, I think had a very good day in the Arlington case. His basic pitch was, all you need is Meade, and this picks up on some of Kristen's very able comments. His argument was, look, you've got this Meade case, which has got this two-part test for when Chevron should apply or something else like Skidmore should apply, and that's kind of complicated. You know, its courts have been sort of struggling with figuring this out, and don't complicate it anymore. You know, don't worry yourselves or instruct the lower courts to worry themselves about whether the agency has authority over this area or not. That's asking too much. Let's just keep it as simple as we've already got it, and all you need is Meade. And I think that explains the extremely odd makeup of the Arlington decision. You had Justice Scalia, who is a fanatic on this question. He's not an impressionist, he's a fanatic. He thinks that Chevron should apply to everything, and that's the end of the matter. It's not pointillism, it's bright line drawing. And he got Justice Thomas, unfortunately, who previously, as Kristen has described, has been a rather able exponent of Chevron, and what some wag called the three chicks to join him in this decision. And I think the motivation was that Verrilli caught the mood of the day, which is we don't need more complexity. And so in the interest of avoiding more complexity in Chevron land, we have essentially apparently tossed out judicial boundary maintenance over the structure of the federal government. Now, what's the solution, or what can we do here going forward? I think there is perhaps a way out of this problem going forward. And it has to do, again, with good old Meade, as Kristen has described it to you. So Justice Scalia previously had virtually an aneurysm whenever the Meade case was mentioned. He would fulminate endlessly about the case and about the good old all things considered approach and so forth. And he hates Meade because it complexifies what he thought was relatively simple. The untold story of Arlington, or the dirty little secret of Arlington, is that in order to get 4 other justices to join him, Justice Scalia had to swallow a very bitter Meade pill. So when you read toward the end of the opinion by Justice Scalia, you'll find the following interesting passages. The first, it says, the dissent is correct that United States versus Meade Corp. Requires that for Chevron deference to apply, the agency must have received congressional authority to determine the particular matter at issue in a particular manner adopted. No one disputes that. And then later he says, it suffices to decide this case that the preconditions to deference under Chevron are satisfied because Congress has unambiguously vested the FCC with general authority to administer the Communications Act through rulemaking and adjudication, and the agency interpretation at issue was promulgated in the exercise of that authority. That is a direct paraphrase of Meade, or at least the parts of Meade that are clear, the parts that Kristen and I are in our law review article advocated. So Justice Scalia has apparently embraced Meade. Now, why is that significant? I think it's significant because, as Kristen briefly mentioned, the issue in going forward then boils down to how broad or how narrow the delegation of authority to act with the force of law has to be. Justice Scalia seems to write in Arlington that all you need is some general grant of rulemaking out there in the organic statute that establishes the agency, plus something that kind of looks like a rule or has some kind of force of law aspect to it, and bingo, Chevron will apply. Justice Roberts argues that, in fact, a better reading of Chevron and of the cases that follow Chevron is that the court is always asked whether the particular issue before the court was one as to which Congress had delegated authority to act with the force of law. Justice Scalia in future cases will no doubt argue that Arlington settles this in favor of the one rulemaking grant is enough approach, but I think, I hope at least, that Justice Roberts' conception will ultimately prevail here. I'm not sure that the justices that join Justice Scalia in the interests of all you need is Meade will necessarily agree that what Meade means is that one grant of rulemaking is enough. And if in the future the court decides that we're going to look provision by provision to see whether the Congress has granted authority to act with the force of law, what do you get? Well, you basically get judicial monitoring of the boundaries of the agency's action, because through the Meade inquiry, the court can now say either that the agency is or is not acting within the scope of its delegated authority, which is really the issue in Arlington, whether or not courts will engage in that inquiry and will exercise independent judgment in engaging in that inquiry. Everyone agrees that the Meade inquiry is done without deference to the agency. And so if you just take Roberts' little variation on Meade, that we're going to do it provision by provision rather than statute by statute, I think courts are back in the business of monitoring boundaries, which I think is the last remaining robust argument in favor of judicial review of agency action. Thank you.
Well, my learned colleagues have spoken about agencies, administrative agencies. I confess I'm going to do something different. I want to talk about judges. If one looks at all of this from the perspective of agencies, deference can perhaps make some sense. If you look at this from the perspective of judges, however, there's some very sobering questions that arise. In the city of Arlington, Chief Justice Roberts observes, the question whether an agency enjoys interpretive authority must be decided by a court without deference to the agency. And that's true enough, I think. But there's another question, an entirely different sort of question that comes up that didn't get discussed. Even if an agency has congressional authority to interpret, can congressional authorization ever displace the judge's constitutional duty to interpret in their cases? Can congressional authorization of agency interpretation ever relieve the judges of their constitutional duty to decide cases in accord with their own independent judgment about the law. Now, I want to make 5 brief points about this. There's much more to be said, and I will be saying it at great length in a book coming out this spring, and it'll be called, just to get the flavor, Is Administrative Law Unlawful? But I only have 5 much more basic points today. I'm not going to discuss that bigger question. Because today, I think what matters is the role of the judges. That's what deference is really about. It's not about agencies. It's about the judges. First, just as background, we no longer simply have government by law. We also now have government by executive command. Traditionally, the executive cannot issue edicts that bind Americans in the sense of constraining them. Congress can issue binding legislative edicts. Courts can issue binding judicial edicts. We're all familiar with that. But the executive could not do these things. It could only issue binding edicts to the military, not civilians. Now, however, executive commands, both legislative and judicial, reach not only the military, but also civilians. We can hear the faint sound of a march from Prussia, practically, in the background. That the executive command can bind us, that there's no distinction between a military command and an executive command through administrative agency. And mind you, I'm not just inventing this. The early advocates of administrative law expounded this. Second, courts now enforce not merely law, but also executive command, and this alters the very nature of what a court is. Traditionally, courts were courts of law, right? They enforced the law, not other royal or executive commands. Now courts enforce both the law and executive commands. The courts enforce executive rules that constrain Americans. They enforce executive interpretations, which are a form of lawmaking, of course, and they even enforce mere guidance that doesn't even follow the rules of administrative law. Third, in deferring or showing respect, all this conversation about deferring respect, it's like a Gilbert and Sullivan song that, blessedly for you, I will not try to sing, right? The song about deference. In all of this deferring to executive interpretation, etc., the judges abandon their independent judgment and instead accept the judgment of others, right? Traditionally, the very office of a judge, the very office or duty of a judge, was to exercise judgment, independent judgment, the judgment of in the judge's own personal conscience. The judge could not even defer to other judges, let alone the executive. This is why we have the ordering of opinions in conferences, right, where the most junior judge will speak first, because you do not want them deferring to their elders or more seniors on the bench. But now the judges defer to the executive. Traditionally, they could not defer to the judgment of anybody else. They could have clerks, but they could not rely on the judgment of the clerks. The clerks just do research. The judgment was their own. The only thing judges could defer to was the law, right? The law might leave room for others to make decisions, but it's only to the law that a judge can defer. And by the way, this isn't some newfangled stuff. This has been going on for ages. In the Middle Ages, you might think there wasn't much judicial independence, but in fact, one of the most basic principles was the judges could not defer. They could not even defer to commands of the king, who could have their head, their seat of judgment, if you will, removed from the rest of their body. They still would not defer. They were instructed not to defer. They took oaths not to defer. Deference is defined as to leave to another's judgment. In other words, it's a type of submission to somebody else's judgment. Deference, thus, is an abandonment of the judge's own independent judgment. And when judges defer, they abandon not only their judgment, they abandon their very office as judges. But it gets worse. My fourth point is judges thereby systematically exercised biased judgment. We have systematic prejudice favoring the government in cases between the government and Americans. Most administrative proceedings constraining Americans are not benefits cases, but the ones imposing constraints, are agency proceedings against Americans, and these are really substitutes for criminal proceedings. This traditionally was well understood, discussed in the administrative law literature. Now we just pretend there's just no connection between the two. But these are substitutes for criminal proceedings. Yet when the judges defer to administrative interpretations, they defer to the government in a way they would never do in a criminal case. Oh, if a prosecutor comes before a court and says, let me tell you how to interpret this murder statute. And the judge says, oh, yes, we defer to you, prosecutor, of course. And oh, you gave us notice and comment, we defer to you even more, not just respect, deference, prosecutor. It would be laughable, right? So what we have now are judges who, rather than exercise unbiased judgment, predictably defer to the judgment of one of the parties. This is systematic bias, and once again, an abandonment of the very office of a judge. And finally, a fifth point. This is not a new question. Deference to agency interpretation is often said to be a new question, and it's said on this basis that it could not have been anticipated by the Constitution, and therefore we have to all just make it up as we go along. In fact, this was a well-known danger. James I, yes, James I, great American hero to the administrative law field. James I, oh, no, you think that's just a joke, right? The early 20th century literature on administrative law is replete to references to James I. He wasn't as bad, as you think. In fact, he had some point with all those proclamations and whatnot. So this is in the leading literature on administrative law in the era. James I sought to govern through the extra-legal power of his agencies. He called them tribunals rather than agencies, but whatever. He called them prerogative agencies. We call them administrative agencies, tomato, tomato, prerogative, administrative. It's all the same. Indeed, James insisted on judicial deference to, and here he used exactly the same words, to his regulations. The Star Chamber was such an agency. It issued regulations. It even issued regulations by decree, as we see in some of the older administrative agencies today. And they had interpretations, which, according to the Roman law tradition, are a mode of lawmaking. See, administrative law actually isn't so new. It actually comes out of a very learned and rather dangerous tradition. But the judges were common law judges. And although they bowed to James on many things, not on this. As early as 1610, they refused to defer to prerogative interpretations. They had to bow to the king. They even sometimes had to get on their knees before the king. Chief Justice Cook famously had to get on his knees before James, and he was trembling, almost crying. But he still spoke back. Even on his knees, he refused to defer to executive interpretation. Like Cook, the Constitution rejected deference to executive interpretation. It placed judicial power in the courts, not the executive. It staffed the courts with judges who must exercise independent judgment. As John Marshall said, it is emphatically the duty of the judicial department to say what the law is, not just authority, their duty. Those who apply the rule in particular cases must of necessity expound and interpret the rule. Of necessity, they must do this. Now, however, the judges scramble to defer to executive interpretation. Can we defer more and more? James would have been impressed. We now have James's deference, but in a republic. In summary, first, government by law has been largely displaced by government by command, executive command. Two, courts of law have become courts of executive commands, not just of law. Three, independent judgment of the judges has given way to deference to the judgment of others. Fourth, unbiased judgment has given way to systematic bias favoring the government's position. And fifth, this is exactly what the judges rejected already in 1610 and the Constitution rejected in 1789. I want to close by pointing out that it's important to recognize these realities. I will be told, perhaps even by members of this learned panel, that it's unrealistic to go along with all of this because the doctrine has moved on and I should move along too, right? But it's still important to understand the realities. Doctrine is one thing, but the realities we cannot hide from, and we have to always keep them in mind. Why? We have doctrinal choices every day. Each year a new case comes along to extend deference or to contract it. And because deference turns out in reality to be an abandonment of judicial office, it is time for the judges to retreat from judicial deference. regardless of any congressional authority for the executive to interpret for its purposes, the judges have the constitutional authority and the duty to decide cases in accord with their own independent judgment about the law. And therefore, when judges defer to the judgment of agencies about interpretation, the judges are abandoning their office or duty as judges. Thank you.
Well, is it time to move along? Is it time to, and just accept this, or should we, should the courts push back? Professor, do you have any other comments that you want to make?
Well, I will say, as Phil anticipated, as much as I am sympathetic to the idea that we should continue to protest the idea of deference to agencies on some level, I do think the horse is out of the barn, at which point it becomes a matter of curtailing by increment rather than curtailing wholesale. So, I suppose there's an extent to which, the rest of us are talking about the extent to which we curtail by increment.
Professor Zellweger?
Just one follow-up point, and again, going back, if you take a consequentialist view about what you think courts want to do, and whenever I hear the word rule of law and courts being involved, I think there's always sometimes a presumption behind that, depending on whatever your philosophical and ideological point of view is, that there's some affinity between what you think the rule of law is and some substantive policy, like the Leviathan will be checked or something like that. And the reality is, in American history, if you're a very good student, there's very, very little record that the courts have ever played a role in checking the Leviathan. They are, in most cases, the prime facilitator of the Leviathan. If you took them away from the picture, you probably have a much different state and different variety. You probably have much more open conflict, much more lack of resolution between the federal and state governments about what the boundaries of authorities are, much more lack of resolution between boundaries between agencies. When the courts come in, what they usually do is they say, this is where the boundary is drawn. And a lot of time, they favor decentralization of power. They've said to the president, you win. They said to the federal government, the states lose. They said to the other agency, you can expand. And that's the rule of law. So you have to be very careful as to what you think that means, because it may not mean substantively, right, what you think it means. Right? It's just a court speaking, right? It's a resolution. It doesn't necessarily mean that they're checking. So I just want to leave it at that.
A couple quick points in response to Philip, some of which he's heard before. One interesting thing about Arlington was that there was a discussion in the opinions of whether or not Chevron deference is consistent with the idea that judges have this duty to uphold the law. The Administrative Procedure Act, in fact, instructs judges to decide independently all questions of law. And the answer given by Chief Justice Roberts, at least, was that Chevron-style deference is consistent with that because it rests on the understanding that Congress has directed the agency to decide. When Congress creates an ambiguity and gives an agency authority to administer a particular statute, that is Congress's decision to have the agency decide the meaning of the statute and resolve the ambiguity. And so that's consistent with the rule of law. You're sort of tracing Congress's directions through a delegation to the agency. What's not consistent with the duty to enforce the law is for courts to defer to the agency's understanding that it has been given authority to decide this question. That is to allow the whole structure of government to be bootstrapped into deference to agencies and really throws the rule of law out the window. And I think, so there is a distinction between agencies' resolutions of ambiguities where Congress has clearly delegated authority to them and where Congress is not. With respect to good old King James, the prerogative that Philip's talking about was one that the king asserted based on his own inherent authority. The stuff we talk about today is where Congress has, by majoritarian democratic processes, decided to delegate authority to the executive branch. and the executive branch then exercises that delegated authority. So there's, in my mind at least, a distinction between claims of inherent power by the executive, which I think are deeply troubling and threatening to our liberties, and claims to be exercising delegated authority within the scope of that delegated authority. Of course, to make sure that the latter doesn't sort of bleed over into the former, courts have to decide whether or not agencies are acting within the scope of their authority.
Thank you very much. On a minor historical point, actually, I would disagree with Tom on this. A lot of the authority claimed by English kings in their prerogative or administrative rulemaking interpretation was actually based on statute. Sometimes they acted with statute, sometimes without statute, and it's actually very complicated. But they sometimes actually had some statutory authority. But I don't want to rest on that. It seems to me there's something really much more fundamental going on here, and nor is this what I'm arguing really, nor is this really in opposition to other academics. It's really, at least here, this is really about a conversation I want to have with judges. It's not about campaigning against administrative law, but I think judges have to sit back and actually think about where they want to be on this. Who are judges? What is their identity and office and duty? And do they want to bring themselves into profound historical contempt, the contempt of history, for having abandoned the very role of a judge at common law? And that, I think, is the very sobering question here. Sure, I'm actually not very fond of the idea that Congress can give authority to agencies, the power to regulate, but that's another conversation for another day. Read my book if you care, don't. If you don't want to, it doesn't really matter. The conversation here, no, it's not what this conversation is about. This conversation is not about rulemaking so much as interpretation and deference to interpretation. And that is what raises this question about the role of the judges. The reality is that even if Congress can, under the Constitution, give authority to interpret to an agency for its purposes, whether congressional purposes or the agency's purposes, there remains this sobering question about what do judges do? And judges have as their duty, their very office and identity, to decide cases and to decide questions of law in those cases, and that inevitably means interpretation. And I don't think judges can hide from that. Thank you.
We have a number of people who have lined up to ask the distinguished panel some questions. We'll start with a question from on this side of the room.
Sure. I'd like to, this is Professor Rod Sullivan from Florida Coastal School of Law. I'd like to direct my question to Professor Merrill, though. Do you think that the Chevron doctrine has really been used as a political tool in the last 20 years, and the experience has become that this is more a tool of politics than it is a rule of law? And I would point you specifically to the area of climate change in Massachusetts versus EPA. During a Republican administration, we had a determination that CO2 was not a pollutant under the Clean Air Act and therefore could not be regulated without additional legislation. This area was hotly debated in Congress, and then the Supreme Court reached in over Congress and plucked the entire area of global climate change and gave it to the EPA, determining that CO2 was, during a Democrat administration, determining that in fact CO2 was a pollutant. Do you think that this refusal to give deference to Republican attempts to restrain the growth of government and giving deference to Democratic administrations who want to grow government really means that Chevron is nothing more than a means for judges to express their personal opinions through judicial decision making?
Well, that's an interesting question. I think there's not a strong political valence in the Chevron cases. There have been a number of empirical studies, both looking at the Supreme Court itself and also looking at courts of appeals. And it's hard to detect a strong political impact that Chevron has had, either in terms of pro-agency or anti-agency. I would say that Chevron is an important decision because it sort of changes the vocabulary and it changes the conceptual framework in which judges discuss these issues, and in so doing it sort of highlights certain questions like delegation, and it submerges other questions like, you know, the reliance interest that people may have had in particular executive interpretations. So I don't think the decision is trivial by any means, but I don't really see it as having a strong political valence. Massachusetts versus EPA, don't get me started on this. Obama administration rescinded the interpretation of pollutant that was rendered by the Bush administration. So if there was to be any deference, it would be to the Obama administration interpretation, which was that carbon dioxide and other greenhouse gases are pollutants. But Justice Stevens, the author of Chevron, wrote a quintessential activist step one Chevron decision, which gave deference to nobody. In fact, if you're a fan of textualism and plain meaning, you couldn't find a more textualist, plain meaning decision than Massachusetts versus EPA, which just said, "Oh, the dictionary or the statute defines pollutant to mean this and this and this. Greenhouse gases include that. Therefore, greenhouse gases are pollutants." No consideration was given to the structure of the act, how radically incomprehensible it would be to apply greenhouse gases under the Clean Air Act, given the structure of the Clean Air Act. And so, yes, it was a politically motivated decision. It was a decision designed to send a shot across the bow of what the court regarded as foot dragging on the question of regulating greenhouse gases. But that's something courts can do with or without Chevron.
Does anyone else want to respond to that, or we want to move to the next question?
Oh, thank you. Regarding independent adjudicatory agencies, I questioned whether or not the name Chevron should be changed to BP, British Petroleum, if you get the humor. The bottom line is, if you do a statistical analysis, when the National Labor Relations Board evaluates cases and comes up with standards to apply to determine whether the act has been violated or not, and when in the course of 30 years or 20 years or even 4 years, the case decision leading to a new standard, the precedent has been flip-flopped anywhere from 3 times to 8 times. There's a direct correlation between the flip-flopping and the jamming of the political majority on the board. And I can assure you that almost every labor lawyer I speak with wants the National Labor Relations Act to be amended to establish all cases go from the administrative law judge to an Article III federal district court. There is no way to suggest that deference to administrative expertise is appropriate when you get outcomes that are directly correlative to the political majority on the board.
So is that your question?
My question is, I wanted to make sure that all of you agree, yes or no.
Any of you?
I was going to say one thing very quickly with respect to this kind of question is that, again, on a very specific narrow issue on the question of City of Arlington, these issues, and I think Justice Scalia makes it clear, there's no judicial abdication here, right? I mean, apply step 2 rigorously, apply step 1 rigorously. If an agency is doing something that is unreasonable, it will be struck down. The deference thing there has to do with jurisdiction. And the question is whether or not that poses, if you want to call it, more cost and benefit. So the kinds of issues that you bring up, what I'm suggesting is that there may be ways to patrol that Chevron is not necessarily tampering with, because if it looks like the agency is really behaving in a politically crass way, a court can strike it down based upon either a plain meaning or an arbitrary capricious standard under the step 2. So.
I would just want to generalize from the comment, just simply to observe that every time an agency makes an adjudication that binds an American or purports to bind an American, that deprives them of their due process, their procedural due process, right? Due process isn't just due process, it's due process of law, not executive commands. Due process of law in a court of law. And I don't think we can address any of the issues in any particular agency without recognizing just the breadth of this assault on constitutional rights.
Professor Merrill, did you have something you needed to add?
Yeah, I answered the first question erroneously. Massachusetts versus EPA was decided before the Obama administration took office. The problem, the General Counsel's interpretation had flip-flopped from an earlier one that said that greenhouse gases were covered during the Clinton administration to the Bush II administration saying they were not covered. But the interpretation was in a council opinion letter. It was not in a regulation having the force of law, so it would not have been entitled to Chevron deference. Anyway, the court didn't talk about deference of any sort in that opinion.
I believe we have another question.
Yeah, I fear I'm terribly out of my depth on this question, but I'm just wondering if the issues that you've been discussing on this very interesting panel have any relationship to the seemingly very elastic interpretation coming out of HHS with respect to the enforcement of the Affordable Care Act.
Any takers?
Well, the most recent interpretation came from a White House press conference. I don't know where that rates under Chevron, but I don't think it rates under
Ditto.
Can't top that.
Question?
Yes, ma'am. One of the common justifications for deference to administrative agencies is that they have greater expertise than common law judges. Professor Hamburg, I'd like to hear your response to that. And also, should we completely throw out any kind of protections that might be provided by administrative law judges because they aren't Article III?
So on the first question, yes, for a century or actually longer, administrative rules have been justified on the basis of expertise. This is really rather puzzling because, of course, Congress has a lot of expertise. And in fact, all the agencies can put all their expertise into a bill and bring it to Congress. There is nothing peculiar about administrative law that makes it more based on expertise than any other sort of lawmaking. So it seems to me the expertise justification is really a distraction. Of course, agencies have a lot of expertise, but that doesn't mean anything about the lawmaking. In fact, the lawmaker in administrative law is usually the head of the agency, who's usually a political appointment, who very rarely has much of the relevant expertise, often has political expertise, which is just like Congress. So who knows? There's also the problem, of course, that the expertise that you tend to find in agencies is usually the expertise of the past decade or two or three or four. There's really something rather odd about taking past science and knowledge and codifying it in a way that actually restricts what's done in the private sector. I could go on at great length actually about this because the theories of science behind this are just puzzling beyond belief. Most scientific knowledge actually isn't fixed knowledge, it's actually just hypothesis, and you really have to be on the edge of that to be able to understand it. And the folks in the agencies often candidly say that we don't have the expertise. And it actually then invite, of course, private people, the people they're regulating, to come in and make the regulations, oddly enough, which actually just feeds the whole purpose of the system, it seems.
Anyone else? Okay, our next question.
Good morning, Greg Bedell from the Chicago Lawyers Chapter. My question is specifically for Professor Hamburger. Given two realities, one, I would agree with Professor Hickman that Chevron horse has left the barn. And the second being, I don't know any lawyer or litigant that's happy with the administrative review process from soup to nuts. Do you think it would be possible to draft any sort of effective constitutional amendment that could rein in delegated authority and end the administrative state?
Okay, so I actually would be against any sort of amendment. It strikes me this is something to be done at a much more practical level, and there's nothing pie in the sky about what I'm saying. It seems to me every time one argues an administrative case in front of a judge, one needs to make clear to them that their very office is at stake. Judges handle this and have gone the direction they have, thinking that they're dealing with other people's problems. It has to be simply made clear to the judges, actually, this is their reputation and their problem, and they cannot escape that. This won't persuade all judges, but once the judges begin to be confronted with the reality that people understand what's going on, then the judges will begin to back off. It's not to say that one's necessarily going to get one grand case that's going to alter this, but I think it is simply bizarre to suggest the horse is out of the barn, therefore just sit back and watch. You know, if you're a farmer, the cow has nudged open the gate and is wandering down the road. Oh, you just sit back, put some straw in your mouth and watch, right? No, of course not. We have other modes. You get ahead of the cow and you gently bring it back. If not so gently, more forcefully. This is not. We would have no politics if we all had this sort of defeatist attitude. Oh, they won. Okay. There's a lot at stake here, right? It's not just. We have to remember this isn't just politics. And if we treat it as politics, we've got a problem. If we treat it as an economic question, as many of my learned colleagues do, I think that's a problem because it isn't about one economic system rather than another. This is about whether or not we're going to have the cases that control our lives decided by persons who are independent judges or just the prosecutor. And once that's understood, I think judges will have to back off. They should be scared, actually, because they're stepping outside their role of judges. And judges have always been respected while they remain within their office, not otherwise.
Well, I have a question. What is the diligent, conscientious lower court judge supposed to do? Are they supposed to be concerned with the fundamental abdication of their duties? Or are they supposed to take out their handy-dandy decision tree? Or should, given this painting, this tapestry, these different techniques, given the discussions of the mirages and all of these lovely things, what is the diligent lower court judge supposed to do?
Well, I think when it comes down to it, it's really fundamentally on some level about trying to take into account all of the concerns that I think Phil rightly raises, but at the same time respect stare decisis. Particularly for lower courts, you don't have a whole lot of choice but to live with Chevron and Meade, et cetera. The real question then becomes how you interpret those cases and apply them, particularly in the hard scenarios. And, when it comes to the impressionist model versus this decision tree model, it's 6 one way, half dozen the other, as far as I'm concerned. Either one of them strikes me as a plausible interpretation of Chevron and Meade. So perhaps in trying to decide which approach to apply, you ask yourself, well, okay, how do these values that Phil emphasizes play through those two different models? But stare decisis is what it is. I don't think you can put the horse back in the barn. The Supreme Court may be able to, but lower court judges don't have that luxury.
I would certainly urge you to read Arlington narrowly. In terms of boundary maintenance, the law has got a lot of things that are very inconsistent with Arlington. For example, preemption has been a very hot issue in the court in recent years, and in a number of those cases, questions arose as to how much deference the court should give to federal administrative agencies as to whether or not the statutes that they administer preempt certain types of state tort suits or other types of state action. In none of those cases was the court willing to give Chevron deference to federal administrative agencies on the question of whether the statute had preemptive effect. The court, in the most elaborate decision of Wyeth versus Levine, said it was something more like Skidmore deference, but not Chevron deference. But the law in that area, it very much reflects a resistance to courts going whole hog and just letting the agency decide the preemption question. When there's a constitutional issue in the case, whether it be a question of federal constitutional power under the Commerce Clause or some kind of individual rights provision, the courts don't defer to agencies on those questions. They exercise independent judgment. So I think I would not read Arlington to say that when boundary maintenance questions come up, just throw up your hands and say, whatever the agency says it sounds reasonable, I will go along with. I think that that decision is an outlier in terms of the larger tapestry of the law that we have, and we have to wait for another decision or two before we can read it for all it's worth.
3 quick points. First, judges take an oath of office. If they don't want to be judges, they should just get off the bench. Second, The earliest essay on judicial review, the 1786 essay by the great lawyer James Iredell from North Carolina, explains this very point. He says, so many opponents of what we call judicial review, actually the duty to follow the law in your decisions, many people say, oh, leave that to the highest court. If there is this power, then inevitably the local county courts run by justices of the peace will have to do this. And Iredell responds, yes, that's right. Every judge has this duty. They cannot escape it. Even the county courts, he concludes his essay, have this duty. And then third, and this echoes what Tom had to say, look, judges have a lot of leeway in there to follow in following precedent. You can follow precedent narrowly. Indeed, one can distinguish between one's opinion and one's judgment in the case. It may be, even when you can't do something narrowly, you can say, well, following precedent, if that's the perspective you take in precedent. But judges remain free and perhaps have a duty then in their opinions to explain, look, this is not what's lawful. I can do this only contingently on the hope that the Supreme Court changes this. And I suppose I might add, of course, lower courts for centuries have served their duty by following the law and giving higher courts a chance to do so too after the higher courts have made mistakes. This is the role of lower courts.
Could I just one thing to all of that? I was going to say one of the problems, and I think there's an article by Adrian Vermeule called Mead in the Trenches, and what he tries to do is look at how Mead has actually been applied in the DC Circuit, and he finds that it's all over the map, right? Courts literally on a panel-by-panel basis. It's not we're applying the law and we reach different outcomes. It's they're applying different conceptions of the law. I mean, that's not good. That's not rule of law. And this is what happens in a lot of these situations when you have hydra-headed deference doctrines. I can go over there and slip into this deference if the following thing comes up. It's that courts genuinely end up confused. And I just want to give you an example. We all discuss City of Arlington as if we know what it's about. It was granted cert on the question as to whether or not Chevron should apply when you're reviewing determination of an agency's own jurisdiction. City of Arlington decided during oral argument when it's going to file its briefing that it would rather not have that be what it would like to address. It changed it to interpretive authority. Scalia hammered this issue, saying, well, we granted a question about jurisdiction. What's this business about interpretive authority? The dissent, that is Justice Roberts, focuses on interpretive authority. Now, if everybody's getting confused about the difference between interpretive authority and jurisdiction and why they're fighting these fights, it's a little bit complicated, it's ambiguous, it's confusing, it's not clear. I read it 3 times that I know what the boundaries between interpretive authority or what the strategic policy between using interpretive authority rather than jurisdiction are. And courts will. And in the trenches, when these things get litigated, they get all over the place. And you could say, oh, the courts are patrolling the boundaries. No, what they do is different people go home and they say, you know what, you have different laws you can observe. And in the DC Circuit, if Judge Santel and Judge Garland are on your panel, you may have a different view of what the deference will be. And if Judge Williams is more like Scalia. He tries to apply, he wants a clean Chevron deference rule. You have a different rule. And I'll give you one example. I try to figure out what it is in the DC Circuit with respect to jurisdiction. I came up with 3 different laws that were coexisting at the same time. One that said if there's a split among agencies about what the boundary of jurisdiction is, that is if there are 2 agencies or 3 agencies where there could be that had interpretive authority, there shouldn't be any deference. This is strange because in 1994, when the first case in the DC Circuit that discussed this came about, it always involved a possible other agency that could have authority. So almost all the cases that I found where they said, no, you should defer, there was also another agency that could have interpretive authority. It could be a state agency, just as it was in the City of Arlington. So the question is, now we have 2 different deference doctrines about jurisdiction that we're wandering around in the DC, and it depends. One panel may apply it and the other won't. And that's not, these are people who've been working on administrative law. These are, unquote, the expert judges who've been working on administrative law for dozens and dozens of years, and they're having this kind of mess. Imagine what it is in district courts and places all over where people have to hit this once at a time. It's just clarity is much better, even if it's not clarity in the angle that you like. And Chevron every person who practices law, it flows right off the top of their teeth. It's a clear rule that everybody could understand, and it's probably much better to jam things into that rule than to have 3 or 4 places where they can leak. And that's sort of my impression of what happens in district courts.
Okay. Well, I do want to respond to that on one level, though, and say that talking about Chevron is clear. Chevron's not clear. Just like we're talking about having multiple views of the jurisdictional question or multiple views of what Meade means, we've got multiple views of what Chevron means. Just like, for that matter, when it comes down to statutory interpretation in general, we have broad disagreement over whether we should pursue originalist interpretive methods or textualist methods or purposivist methods. That doesn't, we've been suffering through that lack of clarity for just as long, if not longer, as we've been suffering through the lack of clarity with Chevron and Meade. It all comes down to, just like we have different reasonable interpretations of a particular set of statutory terms, we're likewise going to have disagreements over what precedents mean and how they apply in individual cases. Some cases will be clear. It's the marginal cases that are always hard, no matter what doctrine you're applying.
Okay, I believe we have time for one more question, and I think it's this side of the room's turn.
Right. I want to acknowledge Chide's stirring appeal to be careful what you wish for in discussing concerns about Chevron. And I think he's right in a case that was essentially playing out that factional dispute between big oil and some alphabet soup of environmental groups, which that is, in a way, a political question that could be handled. But I wonder, Tom, if you've too quickly surrendered the area of judicial review for more individualized plaintiffs in this area when you take a case like Sackett, which I don't think revolved on Chevron, but maybe was a boundary drawing case, where I think the courts can be convinced they ought to perhaps have a different kind of deference depending on the nature of those contending.
No, I think you're exactly right that Sackett's an important case, and it underscores the Supreme Court's understanding that agencies should not be able to coerce individuals. This was a wetlands regulation case where EPA was arguing that it could issue orders to parties about not filling wetlands and could somehow evade any judicial review of those enforcement orders until various eons had passed. And the Supreme Court said, no, this is an adjudicative order. You get judicial review of this under the Administrative Procedure Act. So you're absolutely right that that's an important boundary maintenance decision, and it sort of underscores that judicial review is still important for protecting individual rights. My point was that once you get to the actual reviewing of these individual rights where fact issues are particularly important, the courts many years ago said that they will defer to fact-finding by agencies unless it lacks substantial evidence or is arbitrary and capricious. And so the one thing that courts are really good at, which is fact-finding, has been handed over to the agencies. And the courts will only interfere if there's some kind of really obvious miscarriage of justice, and that's deference, and that's a kind of weakening of one function of judicial review, which I think suggests that the judicial review is not performing the robust function it might otherwise perform in that area.
Do any of our other panelists have final thoughts? Well, let's thank our panelists for such a thought-provoking discussion.